Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I'm going to continue to talk about the Ontario stay-at-home order and the associated new rules. If you didn't watch my last video, basically they put in a stay-at-home order that included a provision that would allow the police to stop you pretty much whenever they felt like it in order to ask you to provide your home address as well as where you're going and why. This was properly criticized by everybody, quite notably including a number of police departments. This is pretty much unprecedented. I have never before heard of a situation where the police were offered extra powers and went, no, that's a little screwed up. We don't want that. This just doesn't happen. This is unreal that the police are going, no, thank you. So when the police are saying we don't want those extra powers, you know somebody has really screwed up. So now, as a result of this, we've got an announcement that they are walking back these powers. I'm looking at an article here. The headline is, Ontario retracts COVID-19 restrictions after criticism from medical experts and police, which sounds a lot like, we won, guys. Let's have a look at what they say here. They say, Ontario is walking back the increased powers it gave to police. Solicitor General Sylvia Jones says police won't be allowed to randomly stop any pedestrian or driver to ask for their home address and reason for being out of their residence. Police will only be allowed to ask people for that information if they believe they're participating in an organized public event or social gathering. Sounds great, right? We won. Yay! Or maybe this is one of those situations where they fix things by making them worse. Spoilers. All right, let's go and have a look at the regulation and what it does, because it's always important to go down to the text of the regulation just so that we know what they're doing, because they haven't always been accurate with what they're telling us they're doing. So let's have a look. So Schedule 2.1 is revoked and the following substituted. So they're getting rid of the old bit, which actually is kind of a bit of a treadmill at this point. They put something in, they get rid of it. They put a new thing in, they get rid of it. It's normally we don't see that many amendments in that short of a time, but here we go. So requirement to provide information. Where a police officer or other provincial offences officer has reason to suspect that an individual may be participating in a gathering that is prohibited by Clause 1(1)(c) of Schedule 4 of Ontario Regulation Rules for Areas in Stage 1, made under the Reopening Ontario, a Flexible Response to COVID-19 Act 2020. Let's stop here, and we will just hop over and have a look at what 1(1)(c) is. So that is gatherings, Stage 1 areas. Subject to Sections 2 to 4, no person shall attend. So that's 1(1). C, an organized public event or social gathering of more than 5 people that is held outdoors, including a social gathering associated with a gathering described in Clause D. And Clause D is an indoor gathering for the purpose of a wedding, funeral, or religious service, rite, or ceremony where the number of persons occupying any particular room in a building or structure exceeds 15% of the capacity of the room. So the C as applied to D is basically if there's a wedding and they've got part of it outside, then that part still applies to part C. So 2 provides that a person attending an organized public event, social gathering, or gathering for the purpose of a wedding, funeral, or religious service shall comply with public health guidance on physical distancing. For greater certainty, subsections 1 and 2 apply with respect to an organized public event, social gathering, or a gathering for the purposes of wedding, funeral, religious service, etc., even if it is held at a private dwelling. And for greater certainty, the number of persons who may attend an outdoor gathering for the purpose of a wedding, funeral, or religious service is limited to the number that can comply with the guidance referred to in Section 2, which is physical distancing. So if you don't have enough distance to have everyone suitably apart, then you can have fewer people than you would otherwise. And Section 1 does not apply with respect to a gathering of members of a single household or a gathering that includes members of a household and one other person from outside that household who lives alone. And the prohibition on attendance at an organized public event in subsection 1(1) do not apply with respect to attendance at a business for a purpose related to providing or receiving the goods or services provided by the business if the business is not required to close under this order. So that's a lot of text, but basically it comes down to this bit, which is an organized public event or social gathering of more than 5 people that is held outdoors, That's what they're talking about here. So that's what they're allowed to investigate. However, let's continue on and read the legislation, and then we'll break it down a little bit further. So, and believes that it would be in the public interest to determine whether the individual is in compliance with that clause. The officer may require the individual to provide information for the purpose of determining whether they are in compliance with that clause. Every individual who is required under subsection 1 to provide a police officer or other provincial offenses officer with information described in that subsection shall promptly comply. And the power described in subsection 1 may only be exercised in a health unit to which that regulation applies. So let's break this down a little bit. They've added a little bit of a requirement that the officer have some information. So that's reason to suspect. Now, reason to suspect is pretty much the lowest standard for the police officer having some information that is actually a standard. So they've improved it here a little bit, because before the officer could just ask you this because you happen to be outside. Now they're saying they have to have some reason to suspect, but reason to suspect is a very low standard. It's way below reasonable and probable grounds to believe, for example. So reason to suspect isn't going to slow them down a lot. They will still be able to ask a lot of people these questions. And there's another sort of addition here, because in their public statements, they've said that the police officers have to believe that you're involved in one of these gatherings. That's not true. That's not accurate when we look at this. They only have to have reason to suspect. But they put in this believes clause. And so, they're making it sound like there's a higher standard here, but it's, and believes that it would be in the public interest to determine whether the individual is compliant with that clause. Well, what kind of test is this? Because I can't really see a circumstance where you could ever actually counter this test. This test is basically, we just write yes in the test section. So there is a part of the test that is, does the officer believe this? But the officer is always going to believe this, because if they didn't believe this, they just wouldn't ask the question. This isn't a further restriction on this in any way. I don't know why they put this in there other than to wedge in the believes language, which actually should have gone up here as, believes on reasonable and probable grounds, as opposed to reason to suspect. However, that's not my big beef with this change. So the officer may require the individual to provide information for the purpose of determining whether they are in compliance with that clause. This isn't just anymore, hey, you have to provide them with your address and where you're going and what you're doing. This is just information, which is basically the officer is going to ask you whatever the heck they feel like, and you're expected to comply. And in fact, if you don't comply, they can, penalize you. So essentially, this is the officer gets to interrogate you, and you don't have the option to refuse. You don't have the option to say no, and you don't have the option to lie, because of course, if you lie to a police officer, that is likely its own criminal offense of obstruction of peace officer, which puts you into a really interesting scenario in a legal sense. Because let's say an officer thinks you're going to some sort of outside gathering. Let's say, for example, you are walking home from work, and it turns out that there's a bunch of people who have decided to go to the park, and they're in the park drinking. And the officer thinks, or suspects that you might be on your way to that group of people who are drinking, and really you're just, you're tired, you're just on your way home. That's all you want to do is just go home. But the officer thinks you're on your way there. So that officer is going to stop you and ask you for information for that purpose. Now, officers are usually not that inclined to believe you when you tell them that you are not doing the thing they think you are doing. So you are into a wonderful scenario here. If you refuse to talk to the officers, which is absent this is the advice, advice lawyers will give you all the time. Absent some rule that requires you to talk, lawyers will always tell you not to talk. In fact, the courts have basically said that this is the role of the lawyer when people phone them up from cells is don't talk, press 1 to repeat this message. But here, now they're saying you don't have that right not to talk to the police officers. So you're saying, oh, well, that's great. I will just tell them what I'm doing, what's going on. Now, the police officer may or may not believe you here. And if he doesn't believe you, he may say, hey, you're lying to the police. And so now I'm going to charge you with obstruct peace officer. And of course, you might be able to get that sorted out in a court later on. But right now you are getting arrested, you're getting charged, you're getting hassled. And, this is going to be expensive for you to get sorted out later. So saying I didn't do it isn't necessarily a great answer here, because you could still get charged because the police officer doesn't believe you. Or you say, hey, I am going to to this thing. We're going to go drink in that park. At which point they say, great, you have confessed to a crime and we are going to charge you with that. So this actually can put you into a scenario where there is no way to avoid being charged when the police officer comes up and gets you. Either one, you shut up and they charge you. Two, they think you're lying and they charge you. Or three, you confess and they charge you. So this is basically a mandatory confessions provision. And I have some serious problems with that. And I suspect that the courts are going to have some serious problems with that serious problems with that as well. I cannot see how this one is going to pass constitutional muster, simply because there is no limit or guidance on what information they need for the purpose of determining whether you are in compliance with that clause. This is a very broad provision. So here they say, we fixed it. Isn't that great? And they fixed it by making it even more shocking. I'm astounded by this. And I'm also astounded by this notion that the real solution to all of this is that police no longer have to investigate offenses. We're just going to insist people confess to them. I kind of feel like if the police think that there is a prohibited gathering, that the police can figure that out without a mandatory confessions clause. Are the police in Ontario just extra bad at their jobs that they can't figure out, hey, those people are in the park drinking? And if you see another guy walking in that direction, you can go, maybe we're going to wait, 30 seconds to see if he joins them and starts drinking, rather than having to go and stop that guy and demand he confess. Is the Ford government saying that the Ontario police are just extra terrible at investigating crimes and they can't investigate crimes or other offenses without these powers? I don't understand. Like, police normally have no problem stopping people for committing offenses without this sort of, and in fact, with not just not having this power, but this being sort of specifically forbidden by the charter. So that's sort of one issue. Another is, again, if the police are going up and stopping people for the purposes of doing this, that may really increase their risk. If you see somebody walking down the street and they're having a walk all on their own, which lots of us are doing in these times, if you can't go out to the bars and whatever else, we still have needs to sort of stay healthy and level. And so we'll do things like go for walks, go for drives alone, this sort of thing where you can still get a change of scenery. If you are getting stopped by a police officer there, that is quite possibly the highest risk part of your walk. So why are they wanting to increase that kind of contact where it's not necessary? And as I said before, I think this would have a real hard time meeting any sort of charter scrutiny, simply because the broad category of just information for the purpose of determining whether they're in compliance, I can't see how that can be seen to be a reasonable limit or sort of a minimal limit. It's just so broad and so concerning. Now, the other thing I want to talk about is salesmanship. And there is a psychological principle that gets discussed for people who are in sales or people in marketing and so forth, that I think is kind of relevant here. And this is the door in the face technique. And what the door in the face technique is let's say you are running, a homeowners association, and it turns out that the pool that everyone, gets access to has a crack in it and it needs to be fixed. And there's, 10 people involved in this organization, and you're going to need $1,000 from each of them. And there's going to be pushback. So instead of sending them a letter saying, hey, everyone, we need $1,000 from each of you, what you do instead is you say, hey, everyone, there's a crack in the pool. What we're going to do is we're going to rip up the pool and build the shiniest new pool ever. And so we need $15,000 from each of you. And everybody shows up at the meeting and they yell at you and they say, you know, you are incompetent. You are terrible. This is the worst thing ever. But this is all part of your plan. This is all just part of the door in the face technique, because then what you do is you say, hey, we've listened to your criticisms. We really, you know, we've been burning the midnight oil. We have been thinking of a new way to deal with this, and we've got a new solution. And that new solution is we can repair the crack, and it's only going to cost you each $1,000. Now people are like, yes, they came up with a new solution. It's only going to cost us $1,000, and they're reaching for their wallets. Whereas if you just ask them for the $1,000 right off, they say, no deal. So that initial big offensive ask can be a way of getting something in that's still a problem, that still people would hate, but they hate it less than the sort of initial ridiculous proposal. Now, that kind of feels like what's going on here, and I cannot read the minds of the people involved in this, so I don't know for certain, but it really seems like this is the possibility. You know, we have put forward a proposal that is so objectionable that now it seems like everybody's going to be saying, oh, well, it's a big win. They're walking it back, you know, good for us. When really this walked back proposal is still really awful, and in fact might even be worse because of the nature of how they've said what information they can collect, which is basically anything they feel like. So it's important to keep the pressure on because this is still really bad. I still have real serious concerns with this. And people, and the other thing I'll comment on is that notwithstanding the fact that various police departments have been saying, we're not going to be enforcing this, don't worry, you know, we're on your side. I'm also hearing from lawyers out in Ontario that they're already seeing people who are being ticketed and already seeing people who are being hassled as a result of these new rules. So, it may be that some police departments are enforcing it, or it may be that some police officers are sort of hearing these new rules and saying, well, I can go ahead and use these, notwithstanding the public statements of the, you know, of my department. So these are concerning. This is not, this is a really big deal here. I'm very much concerned. And I've had some people in the comments say, hey, you know, you get that this is a big deal, you know, the whole pandemic. I absolutely do. But I also think civil rights are a big deal. And I don't think this helps. I don't think this is a solution. This is just giving the police, you know, so the problem here isn't that the police are bad at their jobs and need, you know, special powers. It's not. This doesn't fix the problem. So, you know, as a starting point, any solution to a problem should really kind of help fix the problem, not just give the police sort of carte blanche to do what they want. Anyway, as you will have gathered from this, I don't think this is a big fix. I have serious concerns and wanted to share that because a lot of the media coverage right now is saying, they fixed it, everything is good. And I feel like a lot of people aren't going to be able to dig into the regulations to say, wait a minute, no. So I'm concerned that this is going to be viewed as okay by the public because people just aren't going to have that information. So I'm doing what I can to share that information, and hopefully you guys can make good use of that. Anyway, thank you for watching. I want to, once again, encourage you to like this video, share it with your friends, subscribe to see more content. I think this is a really important issue. I think it's one that is not going to get enough attention. I also want to thank my Patreon supporters at the $50 level: Sir Daniel Wicks of Alberta, Jason Elliott, Canada's National Firearms Association, North Central Process Service, Kyle Martin, Jean-Guy Toussaint, Ivo Nedev, CCFR, BCAMF.org, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited, and at the $20 level, Mark Whittington, Dale Nesbitt, Cameron Johnson, Andrew Elsich, Adam Meester, Marc-Olivier Damour. as well as all of you at the $10 level who will be in the crawl immediately following. Thank you for watching. This is not normally my topic. I've usually tried to avoid discussion of this whole issue. However, when they start trampling on civil rights, that's when I go, okay, I guess I got to make some comment here, because one of the great things about doing criminal defense work is that a lot of the time your fight is a fight for rights of people generally. Usually the Crown's position is we want a right to be viewed as narrow and not applicable in whatever circumstance happens to be up there. That's not to, criticize the Crowns. It's just the nature of the job. However, defense lawyers usually want rights to apply to as many people as possible and to be as big a right as we can, which helps benefit anybody who likes to have those civil rights. So civil rights tends to be our passion. You don't tend to end up in criminal law unless that is something that matters to you a lot, or at least not into criminal defense unless that's something that matters to you a lot. So when I see something like this, I have to speak up. I have to say, wait a second. Anyway, thank you for watching. I hope this has armed you with knowledge.